Chapter 11 Proceedings between Process and Appearance. Article I. Confessos, and Proceedings thereon. Section 205. When and how a bill may be taken for confessed. A defendant is required by the subpoena, or the publication notice, as the case may be, to answer, or make defense to, the bill, and he is given reasonable time so to do. If he fails to do so in the time prescribed by law, and the complainant desires that he shall answer under oath, and make the discovery called for in the bill, the defendant, if served with process, may be attached and compelled to answer, as already shown, but, if no such discovery is sought, the complainant may have an order taking his bill for confessed, the failure of the defendant to make any defense being deemed prima facie evidence that he has no defense to make, but, on the contrary, admits the material allegations of the bill to be true. So, if the defendant puts in a demurrer, plea, or answer, which have been adjudged insufficient, and thereafter fails to file a sufficient answer in the time allowed, he will be deemed to have abandoned all further defense, and to confess the truth of the bill, and the bill may accordingly be taken for confessed by order of the court. Such an order is generally called a judgment pro-confesso. A bill may, under the Code, be taken for confessed in the following cases. 1. When, being duly served with process, as already stated, the defendant fails to plead, answer, or demur, by the time fixed by law. 2. When, an order for his appearance having been duly made and published as prescribed by law, the defendant fails to cause his appearance to be thereupon entered, and to plead, answer, or demur, or to obtain time to answer. 3. When, process of contempt having been returned executed, or the defendant having been brought into court upon such process, he refuses to answer the complainant's bill, or puts in an insufficient answer, so adjudged by the court. 4. When, a plea or demurrer having been overruled, and the defendant ordered to answer the bill, he fails to do so in the time fixed in the order, or, if no time be so fixed, on the next rule day. 5. When, exceptions to an answer having been allowed by the clerk and master, and the defendant or his solicitor notified thereof, and ordered to answer, the defendant fails to file a sufficient answer within 30 days, or to appeal from the order of the master. If the process be a subpoena, or a sire faces, the proof of its service must appear from the return of the officer serving it. If a publication has been made, the fact may be shown by the affidavit of the printer, the actual production of the newspaper in court, or by any other competent evidence. Service of subpoena without copy of the bill will sustain a pro-confesso. The following is the form of an order pro-confesso where subpoena has been served on one defendant, and publication has been made as to another. Order pro-confesso. John Doe versus Richard Roe, et al. Number 618. In this cause, on motion of complainant, and it duly appearing to the court that the defendant, Robert Roe, has been regularly served with subpoena to answer the complainant's bill, and that the defendant, George Stokes, has been regularly brought before the court and made a party to complainant's bill, by publication duly made, and that both said Robert Roe and George Stokes have failed to appear and make defense to said bill, within the time required by law, it is ordered that, as to them, complainant's bill be taken as confessed, and their cause set for hearing ex parte. If a final decree is pronounced at the same time the order pro-confesso is granted, the following addition will be made to the foregoing order, and thereupon, this cause coming on to be further and finally heard upon the bill, the judgment pro-confesso, heretofore taken and entered against the defendants, Robert Roe and George Stokes, and upon the answers of the other defendants and the proof in the cause, from all of which it duly appearing to the court that, and so on, as in case of an ordinary decree, a failure to take a pro-confesso against a proper but not a necessary party, will be treated in the Supreme Court as an informal dismissal of the bill as to him, and when a defendant is liable to a pro-confesso, but the complainant takes a final decree without first taking a pro-confesso, no reversible error is committed. Section 206. Effect of a judgment pro-confesso. As has been said, the failure of a defendant to answer is in the nature of a confession that the bill is true, and that he has no defense to make. Nevertheless, this rule should manifestly be so modified as not to apply 1. To persons under age, or of unsound mind, because they are unable to take care of themselves. 2. To executors or administrators, because they often represent minors and others not parties to the suit. 3. Defendants in divorce suits, because public policy forbids divorces by consent of parties, and 4. To non-residents and persons whose names and residences are unknown, when their property has not been attached, because they have had no actual notice of the suit, and, therefore, cannot be deemed to have confessed the truth of the bill. It has accordingly been enacted that, whenever an order pro confesso is lawfully had, the allegations in the bill are not to be taken as admitted if the defendant is 1. An infant, or 2. A person of unsound mind, or 3. An executor, or administrator, or 4. A person sued for divorce, or 5. A non-resident whose property has not been attached, or 6. A person whose name or residence is unknown. In the excepted cases of infants and persons of unsound mind, the defendant shall appear by guardian, or committee, before the complainant can proceed with his cause. In the other excepted cases, the complainant may proceed as if the allegations of the bill had been put in issue by answer not sworn to, with the right to set the cause for hearing forthwith. On the issue thus made, the complainant may take his proof by filing interrogatories, or giving notice, as hereafter shown. A pro-confesso defendant is in quasi-contempt, and has no right to be heard as to any matter arising out of the allegations of the bill. He can, ordinarily, be heard for one purpose only, and that is on a motion to have the pro-confesso, and proceedings based thereon, set aside. But he can contest any proof taken after the pro-confesso. Section 207. When a judgment pro-confesso may be set aside. The failure of any defendant to make any defense to the bill is in the nature of a contempt of court, as well as an implied confession that the allegations of the bill are true. For these reasons, the law gives the complainant a right to a judgment pro-confesso, as soon as the defendant's default occurs, and the court has no right to deny such a judgment. And after the judgment has been taken, neither the chancellor nor the master has any right to deprive the complainant of the benefit thereof except within the time, in the manner, and on the grounds, specified in the law. The law makes the difficulty of setting aside a pro-confesso somewhat proportionate to the negligence of the defendant. Thus, a defendant who has been served with process, may at any time before final decree, on good cause shown, obtain from the chancellor, or clerk and master, an order setting aside the decree pro-confesso, upon filing a full and sufficient answer, and the payment of costs, and a defendant as to whom publication has been made because 1. Upon inquiry at his usual place of abode, he could not be found so as to be served with process, and there was just ground to believe that he had gone beyond the state, or because 2. The sheriff made return upon a leading process that he was not to be found, or 3. Because a judicial or original attachment had been lawfully levied on his property as a leading process. In all such cases the defendant shall show merits in order to entitle him to appear and defend after judgment by default. On the other hand, a non-resident defendant, or one whose name or place of residence is unknown, and who is not served with process, may appear and defend at any time before final decree, as of course, he not being deemed guilty of any negligence in failing to answer by the time fixed by law. And thus, when 1. Subpoena was served, to have a pro-confesso set aside, merits must be shown and costs paid. 2. When a subpoena was issued but not served, or when no subpoena was issued, but an attachment was levied, the pro-confesso will be set aside on merits being shown and without costs. And 3. When no subpoena was issued, or no attachment levied, the judgment pro-confesso will be set aside, as of course, at any time before final decree, on an answer being filed, without merits being shown, or costs paid. Section 208. How a judgment pro-confesso may be set aside. As a general rule, a judgment pro-confesso may be set aside at any time before final decree and even after final decree, provided the term has not ended, or 30 days elapsed. The rights and liabilities of defendants, in reference to judgments pro-confesso, are widely different, as already shown. and the consideration of those rights will be simplified by dividing all defendants into three classes. 1. All defendants who have been served with process, must show good cause, file a full and sufficient answer, and pay all the accrued costs of the cause, before they are entitled to an order setting aside the decree pro-confessor. 2. Non-resident defendants, or those whose names or places of residence are unknown, and who are not served with process, may appear and defend at any time before final decree, as of course, that is, on mere motion and the tendering of such an answer as the bill calls for. In such case, no affidavit accounting for the delay is required, and the merits of the answer are not considered. When, however, the pro-confessor has been followed by a final decree against such a defendant, the court may require both a sufficient excuse for the delay, and a meritorious answer under oath, before setting aside both the final decree and the pro-confessor, and may also adjudge all the costs accrued in the cause against the defendant, especially where there has been negligence. 3. All other defendants, as to whom personal service is dispensed with under the Code, Section 4352, must show merits, in order to entitle them to appear and defend, after judgment by default. By merits is meant, 1. A sworn answer, showing a meritorious defense, and, 2. A sufficient excuse for the delay, shown by affidavit. In such a case, no costs will be imposed. If, however, there has been a final decree, the court may impose costs. The master may, on a rule day, set aside a pro-confessor, and allow an answer to be filed, but he has not the enlarged discretion of the chancellor in such cases. Before the master can set aside the pro-confessor, and thereby deprive the complainant of his statutory right to a pro-confessor, the defendant must not only show good cause for his neglect, but must tender a sufficient answer. This good cause can only be shown by affidavit. An appeal lies to the chancellor from the action of the master in setting aside, or in refusing to set aside, a judgment pro-confesso. Before a pro-confesso is set aside, in cases where merits must be shown, the chancellor or master should not only require of the defendant an affidavit, sufficiently excusing his seeming default, but should, also, invariably require him to present his proposed answer, in order that a judgment may be formed as to the merits of the defense to be made, and not subject the complainant to the annoyance and delay that may result from any answer, however insufficient, the defendant may think proper to file. The answer thus presented should always be verified by the oath of the defendant, even in cases where the bill waives the defendant's oath, such verification not being for the purpose of substituting a sworn pleading for one not required to be sworn, but exclusively as an evidence of the good faith of the defendant in claiming to have a meritorious defense. It is for the chancellor, and not the defendant, to determine whether a defense is meritorious, and how can he determine that except the answer be read, and that answer properly verified. And when such an answer is presented by a corporation, it should, in like manner, and for like reason, be verified by the oath of the officer, or agent, of the corporation best acquainted with the truth of the contents. One defendant cannot object to the action of the chancellor in setting aside a pro-confessor against a co-defendant. The following form will indicate both the form and the substance of an affidavit to set aside a pro-confessor. John Doe versus Richard Roe, et al. Number 618. The above-named defendant, Richard Roe, deposes and says that, here set out fully and particularly why the answer was not filed in due time, giving the facts on which the defendant relies to show that he was guilty of no negligence, and that his motion to set aside the pro-confessor is made at the first opportunity possible, under the circumstances. Affiant further says that he is advised that he has a meritorious defense to the bill filed against him in the cause, which defense will fully and at large appear by reference to the answer he desires leave to file to said bill, which answer is true to affiant's personal knowledge, and is duly sworn to, and is made a part of this affidavit, and marked A. Affiant, therefore, prays that the order pro-confessor heretofore entered against him in this cause, and the final decree based thereon, be set aside, and for naught held, and that he may be allowed to file said answer, and to have due time thereafter to take his proof. Affiant offers to do equity by paying such costs, and submitting to such orders, as the court may deem it equitable to impose. Richard Roe. Annex Jurat. Counter affidavits will not be heard upon a motion to set aside a pro-confesso, but if the defendant's affidavit calls in question the conduct of the master, the latter may be allowed to make a counter-statement to the court. The following is the form of an order setting aside an order pro-confesso, upon an affidavit explaining the default, and the tender of a sworn answer showing a meritorious defense. Order setting aside a Pro-Confesso. John Doe versus Richard Roe, et al. Number 618. In this cause the defendant, Robert Roe, having by affidavit shown a good excuse for his failure to answer the bill, and having tendered a sworn answer showing merits, on his motion, the judgment pro-confesso heretofore entered and entered against him is set aside, and he is allowed to file said answer, upon the payment of the costs of the cause. Said answer was, thereupon, filed accordingly. An execution will issue against said Robert Roe for said costs. Or, the following shorter form may be used, in this cause, on the defendant Robert Roe's motion, supported by affidavit and a sworn answer, the judgment pro-confesso heretofore taken against him is set aside, on the payment of the costs of the cause, and said answer allowed to be filed. The answer was, thereupon, filed accordingly. Execution is awarded for said costs. Or, if the defendant is a non-resident, or one whose name or residence is unknown, and was brought into court by publication alone, the order may be as follows. In this cause, Samuel Stokes, who is a non-resident, or whose name or residence is unknown, and who was brought before the court by publication only, comes, and by solicitor, or in person, enters his appearance, and, on his motion, the judgment pro-confesso heretofore entered against him, was set aside, and he was allowed to file his answer, which answer was filed accordingly. Section 209. When a final decree may be taken on a pro-confesso. When a judgment pro-confesso is against a defendant not belonging to one of the foregoing accepted classes, so long as it continues in force, it is equivalent to a solemn admission in open court that the material allegations of fact contained in the bill are true, and, for this reason, not only is no further proof of such allegations necessary, but such proof would be immaterial, the confession of record being plenary proof of every fact alleged. If, therefore, the bill alleges enough facts to justify a final decree, taking the facts for admitted, the complainant may, in a case not accepted, take a final decree on his pro-confesso when the cause is reached on the docket for hearing. No final decree can be taken at a special term, in an accepted case, on a pro-confesso taken at the master's rules since the regular term, complainant must wait until the next regular term. A final decree may, however, be taken at a special term on a pro-confesso taken during, or prior to, the preceding regular term. If, however, the bill does not aver sufficient facts, taking them as true, to support a final decree, as when, 1. An accounting is sought, or is necessary, to ascertain the amount due from the defendant, or where, 2. The allegations of the bill are indefinite, or inconclusive, or alternative. In all such cases the complainant cannot, even after a judgment pro-confesso, have a final decree, unless he establish his demand by satisfactory evidence. If, therefore, a final decree be based on a confessed bill, which does not aver enough facts to support such decree, it will be reversible on a bill of review for errors apparent, or on appeal, or on a writ of error. There are 3 cases, however, wherein a final decree cannot be had until the next term after the bill is taken for confessed. 1. When, process of contempt having been returned executed, or the defendant having been brought into court upon such process, he refuses to answer the complainant's bill, or puts in an insufficient answer, so adjudged by the court. 2. When, a plea or demurrer having been overruled, and the defendant ordered to answer the bill, he fails so to do upon a rule given, and 3. When, exceptions to an answer having been allowed by the clerk and master, and the defendant or his solicitor notified thereof, and ordered to answer, the defendant fails to file a sufficient answer within 30 days, or to appeal from the order of the master. In all other cases, where a pro-con so admits the truth of the bill, A final decree may be pronounced at the return term of the process. Section 210. When a pro-confessor will not authorize a final decree. While a judgment pro-confesso, based on service of subpoena, or on attachment of property and publication, is such an admission of the truth of the bill as renders further proof unnecessary, except in those cases where a pro-confesso only makes an issue. Nevertheless, if proof be made by a co-defendant, that the allegations confessed are really false, the court will dismiss the bill as to both defendants, in all cases where such defendants have a common or joint interest in the subject matter of the suit. Thus, 1. Where a bill is filed against two partners, and one answers and disproves the complainant's whole case, while a judgment pro-confesso is taken against the other, the court will dismiss the bill as to both defendants, and 2. Where a beneficiary is pro-confessoct, and the trustee makes defense, and 3. Where a vendee is pro-confessoed, and his vendor answers, and 4. Where one personal representative defends, and the other suffers a judgment by default. In all such cases, the defense by the defendant who answers avails the defendant who does not answer, and, if sufficient, overcomes the effect of the judgment pro-confesso against him. This doctrine, however, is not applied to an answer by a defendant who has distinct rights or liabilities, and no joint or common interest or liability with the party who fails to answer. Nor will a judgment pro-confesso authorize a decree in favor of the complainant, unless the bill shows a ground for relief against the defendant. If the complainant in his bill fails to show such a state of facts as entitles him to a decree, a pro-confessor will avail him nothing, and his bill must be dismissed. This is especially the case where, on a pro-confesso, the complainant asks a decree against a public officer, private agent, or other merely nominal party, as against whom no right of recovery exists. Section 211. Effect of a final decree based on a pro-confesso. There is no difference between the validity, force, or efficacy of a final decree based on a pro-confesso so far as third persons are concerned, and the validity, force, or efficacy of a final decree based on a bill, answer and proof, and a decree based on a pro-confesso, if executed before it is set aside under any of the foregoing provisions, will be a protection to all persons acting upon its validity, and will confer a good title to all property sold under it. It is no objection to the execution of a decree rendered against a defendant, that it was founded on a bill taken for confessed, without personal service, but the court may, and generally ought to, require the complainant to give sufficient security, in such sum as the court deems proper, to abide by and perform such order, touching the restitution of property, or repayment of money, as the court may make, upon the defendant subsequently setting aside the decree, and successfully resisting the complainant's suit. And as between the complainant and the defendant, the final decree against the latter, based on the judgment pro-confesso, is as valid as though pronounced upon answer and proof, until set aside, or reversed, in the manner prescribed by law, and even when the defendant is brought before the court by publication alone, a personal judgment for the debt sued on may be rendered against him, in the same manner, and to the same extent, as though he had been brought before the court by service of subpoena. Section 212. When and how a decree based on a pro-confessor may be set aside. A final decree based on a judgment pro-confesso, against a defendant served with subpoena, may be set aside during the term at which it was rendered, provided not more than 30 days have elapsed since its rendition. After the expiration of the term, or of said limit of 30 days, the decree cannot be set aside, except upon proper proceedings instituted for that purpose, as in case of decrees based on bill, answer and proof. These proceedings in suits brought by original or judicial attachment or property, will be found fully considered under the head of attachment. In all other than attachment cases, a decree without personal service of process against a defendant who does not appear to defend, is not absolute until 3 years from the decree, unless a copy of the decree is served upon the defendant, in which case it becomes absolute if the defendant fails to come forward and make defense within 6 months after service. The death of the defendant proceeded against without personal service, whether the death occur before or after the filing of the bill, does not render the proceedings void, but his heirs or representatives, as the case may be, have the right, within 3 years from the rendition of the final decree, to make themselves parties by petition, verified by affidavit, showing merits, and contesting the complainant's bill. The original defendant, his heir, representative, or assignee claiming under him by virtue of any act done before the commencement of the suit, may, within 6 months after service of a copy of the decree, or within 3 years after the decree when not served with such copy, be admitted to answer the bill, upon petition showing merits, and giving security for the payments of costs, and witnesses on both sides may be examined, and such other proceedings may be had thereon, as if the cause were then newly begun. If the petition show merits on its face, and is not fatally contradicted by the record, it is sufficient, and need not be accompanied by an answer. The proper way to test the sufficiency of the petition is by a motion to dismiss, and in deciding on the motion, the court will look alone to the petition and to the record, and no answer to the petition will be allowed. If the motion to dismiss is overruled, the decree complained of will be set aside, and the defendant allowed to make all defenses of law and fact to the bill, as if the bill had just been filed and process served. Section 213. Forms of petition and decree to set aside a decree based on a Pro-Confessor. The following forms of a petition and a decree will illustrate what has been said in the Proceedings section. Petition to set aside a decree based on a Pro-Confessor. John Doe versus Richard Roe, et al. Number 618. To the Honorable Andrew Allison, Chancellor. Your petitioner, the above-named defendant, Richard Roe, respectfully shows to the court, that on the day of, giving date, the above-named John Doe filed his bill in said cause against petitioner in this court, alleging among other things that petitioner was a non-resident, and praying publication against petitioner. A judgment pro-confessor was at the May term, 1890, of this court, pronounced against petitioner, based on an alleged publication as to petitioner and a supposed default by him, and at the same term a final decree was made in the cause based on the said bill, the deposition of the complainant, and said judgment pro-confesso, by which decree the said complainant was given a recovery of $400, and all the costs of the cause, against petitioner, and execution awarded. Said execution was on, giving date, levied on the following tract of land, the property of petitioner. Here describe it according to the levy, and, also, by a fuller description, if necessary. Said land was sold, under said execution, to the complainant, for the sum of $420, and the sheriff made him a deed therefor accordingly, which deed has been registered, and the complainant is now holding and claiming said land by virtue of said deed, and the previous proceedings in said cause. For a fuller account of all the said proceedings, reference is made to the record in said cause now in this court. 2. Your petitioner positively and solemnly avers and declares that, when said bill was filed, and all the proceedings thereunder had, as herein above stated, he was a non-resident of the state of Tennessee, and a resident of the state of Indiana, that he had no knowledge, whatever, of said proceedings, or of any of them, but was absolutely and wholly ignorant of the filing of the bill, and of all of the orders, decrees, and other proceedings in said cause, until the 3rd day of the present month, January, 1891, when he came to this county on other business, and, greatly to his astonishment, learned of said suit, and of the sale of his said tract of land thereunder. 3. Your petitioner positively and solemnly avers that the cause of action set forth by said complainant in his said bill is, and was at the filing of said bill, wholly false, and without any foundation whatever in fact, or in law. Your petitioner did not owe said complainant any sum on any account whatever at the filing of said bill, or at the time of said decree, and did not owe him the account exhibited to said bill, or any part thereof. Set forth specific denials of the cause of action alleged in the bill, and give any and all explanations, acquaintances, releases, receipts, and c. the petitioner may have, making his defenses as full, clear and strong as possible, according to the facts. Go into details, and remember that this petition is in the nature of an affidavit, and should be positive and specific, and adequate to the end in view. 4. Your petitioner herewith exhibits his answer to said bill, duly verified by his oath, and he makes said answer a part of this petition, and says that said answer is true on his own personal knowledge, and he prays that notice of the filing of this petition be served on said complainant, returnable instanter, and that, on the hearing of this petition, said final decree, and said judgment pro-confessor, and said sheriff's deed, be set aside, and for naught held, and that he be allowed to file said answer, and to take all proper proof. He, also, prays for a writ of restitution to restore to him the said tract of land, or else, that a receiver be appointed to take it in charge until final decree in the cause. Petitioner, also, prays for such other and general relief as he may be entitled to. Richard Roe. Affidavit and jurat as in section 162. Decree setting aside a decree against a non-resident. John Doe versus Richard Roe, et al. Number 618. On this 17th day of January, 1891, came the defendant, Richard Roe, and presented his petition, praying therein that the order pro-confesso and the final decree and other proceedings in this cause be set aside, and that he be allowed to answer the bill, tendering with his said petition an answer, duly sworn to, and notice of the presentation and filing of said petition having been heretofore given the complainant, and he being present by his solicitor, and the said petition and answer, and the original record in the cause, having been read, and argument of counsel heard, the court is of opinion that the petitioner is entitled to have both the order taking the bill for confessed, and the final decree in this cause, set aside, vacated, and for naught held. It is, therefore, ordered and decreed by the court, that said order pro-confesso and said final decree be both set aside and vacated, and the defendant is allowed to file the answer exhibited to his said petition, which answer is filed accordingly, and said petition also, and it being admitted in open court by the complainant, through his solicitor, that the complainant is by his tenant in possession of the tract of land sold in this cause, it is ordered by the court, on motion of the defendant, that a writ of restitution issue to restore to the defendant the possession of said tract, but the tenant in possession will not be ousted until the end of the present year, provided he will it on to the defendant. The cause is remanded to the rules for proof generally, and the defendant is granted leave to cross-examine the complainant, whose deposition has heretofore been taken. After the decree has been set aside, and the answer filed, witnesses on both sides may be examined, and such other proceedings may be had and taken in the cause as if the issue had been duly made up by filing the answer at the appearance term. The effect of the order, allowing the answer to be filed, is to annihilate the interval between publication and the presentation of the petition to set aside the decree, and to give the defendant every right he would have had, if his answer had been filed at the appearance term, and if the term at which it is filed was the appearance term. When a non-resident defendant is permitted to make defense after final decree, he must do so by an answer, and not by admira. Article 2. Motions by complainant. Section 214. Motions and affidavits generally considered. A motion is an oral application to the court in term time, or to the chancellor or master in vacation, for some order in relation to the suit in which the application is made. An affidavit is a statement of facts reduced to writing, and sworn to before some person authorized to administer the oath. Affidavits are ordinarily made in support of motions, in order to bring before the court some fact not otherwise appearing. The subject of motions and affidavits will be hereafter fully considered in articles devoted thereto, but the principal motions and affidavits made in court, or before the chancellor, or master, after service of process, and before the defendant has filed any pleading, will be considered here. Section 215. Motion for leave to amend the bill. Although the complainant may amend his bill before defense made without application to the court, nevertheless, if court be in session when the necessity for an amendment appears, it is proper to move the court for leave to amend. Such a motion may be in the following form: motion and order to amend the bill. John Doe versus Richard Roe, et al. Number 618. In this cause, the complainant moved the court for leave to so amend his bill as to allege that John Brown claims to own an interest in the tract of land sought to be sold for partition in this cause, but that the extent of such interest, if any, is unknown. and so as to make said John Brown a defendant, and require him to discover the nature and extent of his interest, if any, and how evidenced, which motion was by the court allowed, and said amendment was made accordingly on the face of the bill. A subpoena, and a copy of the bill as amended, will issue, and be served on said John Brown. When a motion to amend the bill is made after answer filed, it must ordinarily be supported by affidavit, showing, 1. Why the amendment was not made before, 2. Specifying the substance of the proposed amendment, and 3. Averring that the matter of the proposed amendment is true. The subject of amending bills and of supplemental bills will be hereafter fully treated in a separate chapter. Section 216. Motions in reference to defendants under disability. If his bill is filed against a defendant who is a minor, or a person of unsound mind, without a general guardian, it is the duty of the complainant, at the appearance term, or on or after the appearance rule day, to have a guardian ad litem appointed for such minor, or non-compos. The Chancellor, or Master, may, on motion, make the appointment in vacation, or, if the court be in session, the appointment may be made by the court. The motion and order, if made in court, may be as follows. Order appointing a guardian ad litem. John Doe versus Richard Roe, et al. Number 618. In this cause, the complainant moved the court to appoint a guardian ad litem for Charles Jones, one of the defendants, and it appearing to the court that said Charles Jones is a minor, or person of unsound mind, duly in court by service of process, or by publication, and that he has no general guardian, the court appointed John W. Green, Esquire, a solicitor of the court, guardian ad litem of said Charles Jones, to defend this suit for him. And the said John W. Green in open court accepted said appointment, and filed his answer as such guardian. A guardian ad litem cannot be regularly appointed until the day the person under disability is required to appear, and the appointment cannot be made at all, unless such person has been actually brought before the court, by service of subpoena, or by publication. In contemplation of law, the infant, or lunatic, must be in court in obedience to its process, before the court has such jurisdiction of his person as to authorize it to appoint a guardian ad litem for him. Section 217. Motions for orders pro-confessor. On any rule day after the time allowed for making defense has expired, the complainant may move the court, or master, for an order to take the bill as confessed. In vacation, the defendant has all of the appearance rule day in which to file his defense, and so a pro-confessor cannot be entered against him until the next rule day. If the first day of the term, or any Monday of the term, is appearance day, the defendant must make his defense on appearance day, or on the first 2 days thereafter, or on, or after, the fourth day, he will be liable to a pro-confesso. If the motion is made in court, it may be as follows. Order Pro-Confesso. John Doe versus Richard Roe, et al. Number 618. In this cause the complainant moved the court for a judgment pro-confesso against the defendant Daniel Roe, and it appearing to the court that said Daniel Roe is duly in court, by service of subpoena, or, by publication, requiring him to appear and defend on the first Monday in February, 1891, and that he has failed to make any defense to complainant's bill as required by the rules of this court, it is ordered by the court, that said bill be taken as confessed, as to said Daniel Roe, and the cause set for hearing ex parte, as to him. The taking of pro-confessos has, heretofore, been fully considered, and the reader is referred to the article on that subject. Section 218. Motion for alias, or mezen, process. If the sheriff has failed to find a defendant, or the publication is defective, the complainant should move the court at the appearance term for alias process, to bring the defendant into court, or, in a proper case, he may have a judicial attachment against the defendant's property, and an order for publication. If the court will continue sufficiently long, such alias, or mezen, process may be made returnable to any Monday of the term. The order for alias process may be as follows. Order A or alias process. John Doe versus Richard Roe, et al. Number 618. In this cause, on motion of the complainant, alias subpoena to answer is awarded against the defendant, George Smith, returnable to the 4th Monday of the present term, being the 24th day of the present month. All alias process runs like original process, except that it commands the officer, as he has heretofore been commanded, to do so and so. The following is the form of an alias subpoena. State of Tennessee, Blount County. To the Sheriff of said county. You are hereby commanded, as you have heretofore been, to summon Peter Poe to appear, and see, as in Section 187, ante. If a defendant has died, or married, since served with process, such fact may be proved in open court, and a face is ordered by the court, on motion, against the husband of the married defendant, or the heirs or personal representatives of the deceased defendant. The following is the form of an order for a faces. John Doe versus Richard Roe, et al. Number 618. In this cause, the death of James Jones was suggested and proved in open court. And it being suggested that Henry Jones is his administrator, or that William Jones and George Jones are his heirs at law, it is ordered by the court, on motion of the complainant, that a face is issued to notify said Henry Jones, or said William Jones and George Jones, to appear on some Monday of the term, or at some rule day, specifying the day, and show cause, if any he has, or they have, why this suit should not be revived against him, or them. Section 219, Motions for Attachments for not answering. If the defendant fails to answer a bill seeking a discovery, within the time required by law, the complainant may either take an order pro-confessor against him, or may move the court, or master, for an attachment against the body of the defendant to compel him to answer. In such a case, the motion may be in the following form: Motion for an attachment. John Doe versus Richard Roe, et al. Number 618. In this cause, the complainant moved the court for an attachment against the defendant, George Smith, to compel him to answer the bill, and it appearing to the court, that the subpoena to answer the bill was duly served on the defendant, George Smith, on the 10th day of February, 1891, that he has failed to answer, or make other defense to said bill within the time required by law, and that said bill calls for a discovery from said defendant under oath, it is ordered by the court that an attachment issue against said George Smith for not answering said bill, said attachment to be returnable to Thursday of the present week. The sheriff may take a bail bond in the penalty of $500. Section 220. Motions by complainants in person. There are some motions best made by a complainant in person, or made by a solicitor in his presence. Where a person's name is used as sole complainant, or as co-complainant, without authority, he must take steps to repudiate the suit as soon as he has notice of its existence. If the suit be pending, he should present an affidavit that the bill was filed without authority, and move the court to order the bill taken from the files or dismissed as to him, and that the solicitor filing the same be taxed with all the costs of the cause. Upon such motion the court will hear the evidence, the burden of proof being on the solicitor to show authority. Where the suit has ended before the complainant learns of its existence, and he has suffered any loss by such suit, he should file an original bill in the nature of both a bill to impeach, a decree for fraud, and a bill of review, setting forth the facts, and making the solicitor and all of the parties to the original suit defendants, and praying to be relieved from all liability under the decree complained of, and, if necessary, for an injunction against its enforcement as to him. So, where a complainant complains of, or repudiates, any act of his solicitor, he should do so in person, or, at least, should be present in court at the time his complaint is made. Section 221. Suits by motion in Chancery. Suits may be commenced in the Chancery Court by motion, and decrees rendered summarily, without pleadings, and generally without notice, against certain officers and attorneys, and against those indebted to certain sureties, stayers and endorsers. The proceedings in such suits are wholly foreign to the pleadings and practice in equity, and are purely statutory. They are seldom resorted to in the Chancery Court, and, as they are treated of in books on practice in the circuit courts, and would unnecessarily enlarge this volume, already cumbersome, they will not be further considered.